What will be the real technology law battleground in 2026? Not the laws that are already famous. The real battleground will be the interfaces between rules, like AI compliance, meeting data protection, cybersecurity meeting product regulation, crypto meeting financial supervision, and digital identity reshaping onboarding and fraud prevention. And there is another big question. Will Europe keep tightening the screws, or will it simplify and delay parts of the rulebook to boost competitiveness? Today's episode is different. Instead of a solo deep dive, I'm hosting a roundtable with my DLA Piper colleagues. Each of them will share practical predictions for 2026. And most importantly, we will address how companies should act to avoid surprises later. I'm Giulio Coraggio, a technology and data lawyer at the global law firm DLA Piper. This is the podcast Diritto al Digitale, where we explore the intersection between law and innovation. As anticipated, today it's a special episode. It's an episode dedicated to the 2026 predictions on technology law. You will hear from five of my DLA Piper colleagues. Vincenzo will discuss on digital transformation. Tommaso will discuss about artificial intelligence. Roxana will discuss about data protection. Federico will cover cybersecurity, and Giulio N, to distinguish him from me, on cryptocurrency. After each segment, we will start a short conclusion. So let's start with the innovation on digital transformation. Vincenzo, when we look at digital transformation towards 2026, cloud computing obviously is everywhere. From a legal perspective, what is really changing there?
What is changing is not the technology, but the contractual expectations around it. In 2026, discussion will be less about whether to move to cloud and more about how responsibilities, risk, and regulatory constraints are contractually allocated between providers and customers. Three areas are becoming central in cloud contracts. First, regulatory allocation of roles and obligations, but also frameworks like NIS 2, DORA, the Data Act, and sector-specific rules do not impose obligation only on customers. They also indirectly shape what cloud providers are expected to support contractually. For example, incident cooperation, audit rights, transparency of some contractors, and clear demarcation of responsibilities. So in 2026, cloud agreements will increasingly need to show on paper how compliance is operationally supported, not just referenced.
And Vincenzo, this is particularly relevant when public entities are involved. Is that right?
Yeah, correct. In Italy, when cloud services are provided to public administration, qualification and certification mechanism issued by the Agency for the Cybersecurity come into play. We call the as ACN, which is Agenzia per la Cybersicurezza Nazionale. From a contractual perspective, ACN qualification impacts security commitments, incident management clauses, access control and operational transparency, and alignment between contractual SLAs and regulatory expectation. Even when cloud providers serve private clients, these public sector standards increasingly influence negotiation because large customers want contractual consistency across regulated and non-regulated environments.
Always in the area of cloud computing, another recurring topic is pertaining international data transfers, especially to the current government in the US. How does that translate contractually, Vincenzo?
Yeah, in 2026, the question will not be whether transfer are allowed under a specific framework, but how transfer-related risks are managed contractually over time. Despite the EU-US data privacy framework, companies are aware that the transfer mechanism can be challenged or interpreted. As a result, cloud contracts are evolving in three directions: clearer representation on data location and access scenarios, more granular cooperation obligation in case of regulatory inquiries, and structured fallback mechanism, both technical and contractual, if the legal framework changes. This is not about blocking transfer, it's about predictability and resilience in long-term cloud relationships.
Vincenzo, in 2025, we spoke a lot about the Data Act that came into place and became applicable. So where does the Data Act fit into this picture?
Yes, the Data Act in practice adds another contractual layer. On September 25, cloud contracts must increasingly reflect switching and portability frameworks that are realistic, not only theoretical, balanced termination and transition assistance clause, and also transparency on technical dependencies. In 2026, we will see more detailed cloud contracts, not because parties distract each other, but because regulators and boards expect clarity on exit, continuity, and interoperability.
So just to conclude on digital transformation, Vincenzo, give me one clear prediction for 2026.
I will say in 2026, cloud contracts will be treated as compliance instruments and not just commercial documents.
Definitely a very good point in an environment that is exponentially becoming digital. Let's switch to Tommaso. Tommaso, obviously, in these predictions for 2026, we couldn't avoid talking about artificial intelligence. Artificial intelligence is no longer experimental. So what will be the biggest legal and organizational shift for compliance when AI comes into play?
Thank you for the floor, Giulio. You're right. AI was actually the topic of 2025, and likely it will be also the hot topic for 2026. The real shift that I see is that AI is becoming operational inside organizations. So until now, many companies treated AI as a pilot project, something owned by the innovation teams. I think in 2026, AI systems will increasingly support or directly influence core business processes like HR screenings, customer interaction, pricing, fraud detection. I mean, we have seen many of them assisting our clients. This means that the central issue is no longer only external regulation, it's also internal governance, which will be the key topic. Companies will need AI governance framework that regulates multiple things like who can adopt or deploy AI systems internally, especially in large groups, how AI tools are selected and approved and internally sourced, how risks are assessed before, after deployment, and how AI usage is monitored over time. As we know, these solutions tend also to modify and adapt with more data being ingested. Without this internal framework, I think compliance with external rules becomes impossible without an internal organization.
Yeah, Tommaso, we heard a lot about the EU AI Act. So how does it come into place with a lot of uncertainties in relation to the implementation timing?
Well, we know the digital omnibus is there. It's still not definitive, so we don't know whether the compliance obligation will be pushed to 2027. But what we know is that for the moment, even if there's not yet a clear path regarding the timing, the compliance obligation cannot be delayed because it's 2026 and we have a 6 months gap window between now and the full applicability, at least at the moment. So governance cannot wait for the moment. The EU AI Act pushes organizations towards a risk-based approach. So starting to build a risk-based approach internally is essential. Companies will need to understand and try to comply with the regulation, starting to realize on which AI systems they are using, whether they are developed internally or whether they are buying that somewhere on the external part, and which data they rely on, especially if it's internal data. We know copyright has been a big issue this year. Large number of litigation cases started to appear also in Europe, not just in the US. So it's becoming a hot topic also in Europe. And in practice, this means that it's necessary to set up a central AI inventory. And for that part of activity, maybe companies will need to rely on a legal tech tool, internal approval and escalation processes, and also clear roles and responsibilities, also involving not just legal, but also IT, compliance, security, and business teams. So organizational measures on one side, technical measures on the other, and also tools to make sure everything works together.
Tommaso, maybe a misconception on AI compliance is whether this applies only to companies building AI, providing AI systems, or also to companies using third-party AI tools. Can we clarify the scenario?
Giulio, you're completely right. That's a really common misconception. Let's set this clear. It applies to both. Most organizations in 2026 will primarily be deployers, so companies integrating and buying solutions. not developers, especially in Europe, for what we are seeing at the moment. There are more and more developers coming into the market, but my expectation is that 2026 will be the deployers year. Using third-party AI does not remove responsibility. Let's set this clear. Internal governance framework must also cover procurement standards for AI-enabled services. So this is something that should be taken care of also when purchasing external services. Also, contractor requirements. We have been working a lot on contractor agreements for our clients, helping them to strengthen these agreements. Also, because the third-party vendors are now integrating AI into their services. So every contract now also has to have an AI clause to cover whether you're buying AI or whether you're buying services where AI is part of the service or was used to provide the service. In other words, governance is about how AI is used inside the organization, not just how it is built.
So what is your one concrete prediction for AI in 2026?
I think that in 2026, companies without an internal AI governance framework will definitely struggle. Not because of fines. I do not expect the regulators start to fine and issue sanctions in 2026, but because they will not be able to control how AI actually operates across their business. It will be something essential for them having an internal governance framework.
Thank you, Tommaso. Let's switch to data protection with Roxana. We've been talking about data protection so much over the last years. And data protection now is often described as, let's say, business as usual. But in reality, it keeps evolving. So what will make 2026 different from the past?
Well, in 2026, data protection will increasingly intersect with how organizations justify data use for AI. One of the most debated topics is whether legitimate interest under the GDPR can serve as a legal basis for training AI systems on personal data. And today, there is not an explicit prohibition in the GDPR in this regard. However, at the same time, supervisory authorities and guidance have taken a cautious approach, and often they have been recommending alternatives such as consent or anonymization, both of which are difficult to scale for AI training. This tension will not disappear in 2026, and instead it will become more visible.
So what is driving this debate at the moment?
I would say three elements. Firstly, regulatory pressure. AI training requires large and diverse data sets. Companies need a legally robust basis that is operationally realistic. And legitimate interest is attractive because it allows to conduct a balancing test rather than an all or nothing model. Second, policy initiatives at EU level. We have been talking a lot about the digital omnibus, so a simplification. And there have been proposals and analysis suggesting clearer legal basis for AI training, including a potential sector-specific or purpose-based solution. While outcomes are uncertain, the debate itself will influence how regulators will interpret existing rules in the GDPR in 2026. And lastly, case law and enforcement maturity. Courts and authorities are refining what concepts such as necessity, proportionality, and reasonable expectation mean in a data-intensive environment. This will directly affect the use of legitimate interest as a legal basis for AI training.
So can we say that legitimate interest is the solution for AI training?
Well, this is not a blanket solution, unfortunately. In 2026, legitimate interest will be a viable option. However, it has to be supported by strong safeguards. This includes clear purpose limitation for training, minimization and filtering of data, effective pseudonymization or aggregation, of course, where possible, transparency towards individuals, and documented balancing tests that reflect the actual risks. Without these elements, legitimate interest is a very fragile legal basis, especially when AI outputs affect directly individuals. What we will see in 2026, therefore, is not a single answer, but companies will have a different approach based on their risk appetite. Some organizations will choose to carefully conduct legitimate interests, and others will adopt a more conservative approach.
So what is your one sentence prediction for 2026 in the data protection world?
Well, I will conclude with a question, because in 2026, the debate will shift from can legitimate interest be used for AI training to can you prove that your legitimate interest assessment actually works in practice?
Thank you, Roxana. So when we talk about data protection, we cannot ignore the risks around cybersecurity. Cyber threats have been increasing, especially in connection with the ongoing wars. Federico, cybersecurity is no longer only a technical topic. Looking at 2026, where do you see the main legal and operational risks for companies?
Yes, thank you, Giulio. The biggest risk in 2026 will be surely fragmented incident management. Indeed, cyber attacks today trigger obligation under multiple regulatory framework at the same time. In particular, a single incident can activate GDPR, personal data breach notification, NIS2 incident reporting duties, and for financial entities and their ICT providers, DORA major incident obligations. Many organizations are still managing this regime independently rather than through an integrated approach. In 2026, that approach will become unsustainable.
So why is this becoming so critical now?
That is becoming critical because enforcement and reporting obligation are becoming operational and unavoidable, especially in Italy. Under GDPR, companies are already familiar with the 72-hour breach notification rule, but GDPR is now only one layer. With NIS2, the focus expands beyond personal data. It covers availability, integrity, and continuity of essential and important services. As such, incident reporting is no longer exceptional. It is expected as part of normal governance of every business targeted by this new regulation. Italy has transposed NIS2, and the incident reporting obligation will now be fully in place, with national coordination and supervision led by ACN, the National Agency for Cybersecurity. At the same time, financial entity shall also consider DORA, which require, among other, classification of incidents, strict timeline for reporting, coordination across entities and service providers, as well as structured post-incident reviews. In 2026, regulator will look closely at how companies manage incidents across these regimes, not whether they filed a single notification on time.
Yeah, indeed. So it seems that the issue is not around just reporting, but coordination in reporting and management of incidents.
Yeah, exactly. Indeed, companies need an integrated incident management program that work across GDPR, NIS2, and DORA. This means that companies should work to have in place a single incident escalation and decision-making process, clear criteria for when an event triggers which obligation, predefined roles between legal, IT, security, communication, and management, as well as defined and clear procedures, not improvised responses. Without integration, organization will likely risk inconsistent notification across the different regime, regulatory scrutiny for under or over reporting, and loss of credibilities with national authorities.
So another hot topic when it comes to cybersecurity compliance is the potential liability of the senior management. How exposed are they?
Yeah, absolutely. That's a crucial point for 2026. Both NIS2 and DORA explicitly emphasize management responsibility and accountability. Senior executives are now expected to approve cybersecurity and resilience measure, oversee their implementation, and ensure adequate resources and training. This means that cybersecurity is no longer something technical that can be fully delegated to IT functions, but we require more and more participation by senior management. 2026 regulator will increasingly ask, did top management understand the risk? Were they trained? Did they exercise proper oversight? Training board and senior executives on NIS2 and DORA is therefore not optional. It is a compliance requirement and also a defensive measure.
Let's conclude with the one sentence that summarizes your 2026 in the cybersecurity world. What would that be?
Yeah, thanks. I'd say that in 2026, companies will be judged less on whether they suffered a cyber attack and more on how coherently and responsibly they managed it across GDPR, NIS2, and DORA.
Thank you, Federico. And we couldn't conclude this episode on the predictions without touching issues around cryptocurrency. Giulio, crypto regulation has matured significantly in Europe during the course of the last years, and especially in 2025. So looking at 2026, what do you see as the real shift for the sector?
What I feel is that the real shift is that crypto is moving from being perceived mainly as a speculative asset class to being assessed effectively as a financial infrastructure. And this goes well far beyond payments and includes tokenized assets, programmable utility rights, and on-chain representation of real-world value in a large sense. Anyway, this is particularly true for stablecoin, whether classified as e-money tokens or asset reference tokens, and for the use of crypto asset as a digital payment instrument. Under MiCAR, so-called markets and crypto assets regulation, stable coins are no longer an unregulated experiment. They are indeed becoming regulated instruments with clear governance, reserve, and supervision requirements. What I feel is that in 2026, this regulatory clarity will unlock new opportunities, especially for cross-border payments, treasury optimizations, tokenizations, on-chain settlement, and B2B payment flows that embed stablecoins and where speed and programmability matter.
So, Giulio, my understanding is that regulation is not necessarily slowing innovation in the crypto world.
Yes, as far as crypto are concerned, we can say that regulation and clear and defined rules are actually stimulating certain use cases. And I feel that stable coins can be a really good example in this sense. Once issuers and intermediaries operate under a clear regulatory framework, large corporates and financial institutions become, of course, more comfortable integrating them into payment and settlement processes. But, and this is the key, crypto payment do not exist in a vacuum anymore. When crypto assets are used as a means of payment, they increasingly interact with traditional payment regulation.
Yeah, indeed. And this is where PSD3 comes into place, right?
Yeah, the revised European Union payment framework composed of PSD3, so the third Payment Services Directive, and the new Payment Services Regulation will be highly relevant in 2026 because by then most of the transitional phases under MiCAR will be over and the supervision will be fully operational, even if crypto assets are not necessarily funds in the classic sense from a financial law perspective. Many crypto-related activities will still trigger payment-like obligation, especially when fiat on and off ramps are involved. Stablecoins are used for everyday transaction, or crypto services are embedded into user-facing payment solutions. And this trend will also intersect with the European Union's open finance agenda under the Financial Data Access Regulations, the so-called FIDA, especially where crypto services rely on access to financial data and account information. In practice, crypto operators will need to assess whether parts of their services resemble regulated payment services, how safeguarding transparency and consumer protection rules apply, and how to coordinate MiCAR obligations with the evolving payment framework, as you were saying.
So crypto as a payment tool is becoming more, let's say, realistic, but also more regulated, right?
Yeah, we can see that in 2026, the key challenge will not be whether crypto can be used for payments. It clearly can, but how to design compliant crypto use cases across payments, tokenizations, and especially that data-driven financial services. This includes, for instance, clear segregation between regulated and non-regulated services, a robust governance framework and controls, alignment between crypto regulation and payments law, and of course, careful analysis of the communication to users, especially for what regards marketing initiatives. Companies that succeed will be those that treat compliance as an enabler of scale, not as a constraint.
So what is your prediction for 2026 in the crypto world, summarized in one sentence?
In 2026, stablecoins and crypto payments will move closer to the mainstream, but only for players able to assemble compliant by design models that align MiCAR, payments regulation, and at the same time the EU technology framework from the GDPR to DORA.
Just to summarize what we've been discussing during the last half hour, if we step back and look at these predictions altogether, one pattern really emerges. In 2026, technology law will not be about discovering new regulations. It will be about making different regulatory frameworks work together inside organizations. Digital transformation will no longer be measured by cloud adoption alone, but by how cloud contracts allocate compliance, data transfer risk, exit strategy, and regulatory cooperation, especially in environments influenced by public sector standards and cross-border data flows. Artificial intelligence will stop being a side project, and as AI systems move into daily operations, companies will be expected to demonstrate internal AI governance frameworks, clear rules, usage, monitoring, accountability, regardless of whether AI is built in-house or purchased from third parties. Data protection will remain central, but with a more pragmatic focus. The debate around legitimate interest as a legal basis for AI training shows that the real question for 2026 is not theoretical permissibility, but whether organizations can prove necessity, proportionality, and effective safeguards in practice. Cybersecurity will increasingly test governance under pressure. Cyber attacks will trigger overlapping obligations under the GDPR, NIS2, and DORA, particularly in Italy, where incident reporting obligations are now fully operational. Companies will be judged on their ability to manage incidents currently and on whether top management was informed, trained, and actively accountable. Lastly, in relation to cryptocurrency, that will continue its shift from the margins towards infrastructure. Stablecoins and crypto-based payments will present real opportunities, but only for players capable of aligning MiCA requirements with the evolving payment framework, including PSD3, and with operational resilience expectations. Across all these areas, the common thread is proof that contracts reflect regulatory reality, proof that AI is governed internally, proof that data use is justified and safeguarded, proof that incidents are managed, not improvised, proof that innovation and compliance can scale together. This is why 2026 will not be a year of abstract compliance, but a year where governance choices become business choices. So let me leave with a few questions. Is your organization prepared to manage overlapping obligations, or are compliance frameworks still siloed? Do you know which AI systems are already influencing real decisions inside your business? And are your contracts, cloud, AI, payments, really designed for regulatory change or only for today's rules? If you want to share your perspectives or suggest topics for future episodes, just write to us at our contacts on dlapiper.com. Register for the podcast and activate the small bell so you don't miss the future episodes, and give us a 5 stars on Apple Podcasts or Spotify if you liked our late episode of today. I'm Giulio Coraggio. This is the podcast Diritto al Digitale, and I thank my DLA Piper colleagues Vincenzo Giuffré, Tommaso Ricci, Roxana Smeria, Federico Toscani, and Giulio Napolitano. Arrivederci.